appearances, please.
And Zach Witchow.
Sir, state your name for the record, please.
I'm here as a third-party intervener in this matter. As authorized representative for my client, I accept for value and return for value all of the charging instruments in this matter and make my exemption available for discharge of all obligations and charges connected with this case. I do not dispute any of the facts in the charging instruments, and for the record, I do not consent to or agree to being called that name that you have identified here today.
The record should reflect that the individual known to this court as Darrell Brooks is present in person in custody. Hold on, I'm not going to address any preliminary matters at this point. I've already addressed a number of things yesterday. The jury is to be brought out.
No, there was some things that needed to be discussed about the paperwork from yesterday.
We'll take that up on a break. You can look over it and you can make a note and pass it to my clerk.
I've already looked over it, Your Honor. With all respect, I think there's some things.
Mr. Brooks, I'm not dealing with the paperwork from the clerk of court's office.
Okay, but she should know that she's trying
Mr. Brooks,
get me to pay.
Stop. I am not addressing it.
It has to be addressed, Your
All right,
Honor,
I'm going to take a quick break and make sure the jury is ready. And
if I don't address it now.
All right, thank you. The jury can come on out.
So we're not going to address this civil matter?
No.
I was told to pay for something under a civil statute.
Mr. Brooks, I am not the custodian. Bring it up with the clerk of court.
How am I supposed to do that? So that makes me wonder if this is
Mr. Brooks, the jury's coming out. I'm not going to address your request for open records. I'm not the custodian of the records, sir.
My Sesty Trust is being sued?
Mr. Brooks, this is an irrelevant matter that you're attempting to bring up in the presence of the jury. The record should reflect these interruptions.
Before the jury came out, Your Honor.
And I told you I wasn't going to address it.
Okay, so it's a civil matter. Who's being sued? My Sesty Trust? How can I be
Mr.
sued?
Brooks, you're talking about an irrelevant matter.
It wasn't irrelevant when I got the paperwork from the clerk of courts. I was simply
Mr.
trying
Brooks,
to address it.
I'm not going to address it. The jury will disregard these irrelevant comments.
Matter? We haven't addressed subject matter.
All right, thank you, everyone. Please be seated. The jury will disregard the statements Mr. Brooks is making about subject matter jurisdiction. They are a misstatement of the law.
No,
all right, and
just like this is a civil case.
Mr. Brooks, the jury's here. Please show respect and decorum.
According to this document, this is a
Mr.
civil
Brooks,
case,
please stop.
which means someone is being sued. Civil is a suit.
Mr. Brooks, you're talking about an irrelevant matter.
I have the
I'm starting the trial.
The course right here that says it's a civil matter.
Mr. Brooks has nothing to do with this case.
My Trust is being sued.
I have no idea what you're talking about.
I got the paperwork right here.
All right, I'm going to excuse the jury right now, given this disruption.
This should be properly addressed before the jury even comes out. That's why I tried to properly address it before we even went on the record.
Mr. Brooks, stop.
I'm not going to.
You are not being respectful to this proceeding or to this jury. No, it's not. With all due respect, stating that doesn't make it respectful.
I was given this paperwork by you,
Mr. Brooks.
Monica Paz.
Stop talking till the jury is out.
Okay,
thank you.
So why couldn't we address this before they came out?
I'm not going to address it.
Bottom line. That was the time to address it, though. We're supposed to do all the addressings before the jury comes out.
Please be seated.
I was trying to simply address paperwork that was given to me by you, Your Honor. That states
Mr. Brooks,
you
have interrupted me repeatedly. You are on the verge of being removed to that courtroom. I don't want to do that. I want you to stay here. But you keep interrupting me. I am not going to be the messenger and give you documents that you request. They will simply have to be delivered to you at the jail. I'm not taking it up. It is irrelevant.
It needed to be noted for the record.
It doesn't need to be noted, sir. All right, the jury's coming back out, and I'm going to warn you, if you bring this up again, I will remove you to the next courtroom for being disrespectful, for being interruptive, for being disruptive. You will forfeit your right to be present.
I object to that.
Did you hear what I said, sir?
No, I did not. I object to that.
Well, you can object, and your objection is noted, but if you interrupt when this jury comes out, you will be removed to the next courtroom.
What is the legal basis for that ruling, Your Honor?
Illinois versus Allen, sir, and all of the other cases that I've cited previously. I'll make the appropriate record. Stop interrupting me. We're continuing with this trial despite your repeated efforts to disrupt. Yesterday, sit down. Yesterday alone, 17 interruptions, not including the opportunity that I gave you where you spent 50 minutes, discussing what were primarily either irrelevant or baseless accusations and requests not based in law or fact. I was abundantly patient with you yesterday.
And you still haven't verified by proof any of what I said.
And none of that is required, sir.
Because it is. You can't verify.
Your belief that that's the law doesn't make it so, Mr. Brooks. Your belief that these are legitimate legal positions doesn't change the law and doesn't make it so.
It's
so, again,
relevant because you didn't want to.
I'm going to step off and give Mr. Brooks 5 minutes to cool off, and when that happens, I'm bringing the jury out,
I'm not angry at all.
and then we will
I just wanted
continue.
to. I don't.
Thank you, everyone. Please be seated.
Not addressing subject matter jurisdiction yet again.
Will we please put up exhibit number 15, which has previously been received and published?
Go ahead. Overruled.
Could you draw a little X if you can find where you were standing with your family?
Objection.
Overruled.
Do you want me to go up and touch the map? Is that
Oh, at the screen in front of you. I'm sorry. You can use your finger.
Sure. Okay.
Overruled.
Do you recognize this intersection?
Objection. Hearsay.
Overruled.
Yes, I do.
Do you recall what happened at approximately 4:39 p.m. that Sunday afternoon?
Objection.
Overruled.
I could see that it was a red Ford Escape traveling at a high rate of speed. When it passed by me, it was probably maybe 10 feet away at most.
Do you recall if the vehicle passed through the parking spaces in front of you at all?
Objection. Relevancy.
Overruled.
Yes.
What was the driver doing as he passed you?
Objection. Hearsay.
Overruled.
He stuck his head and actually like the upper portion of his body out the driver's window and looked back behind him.
He actually stuck his head out the window.
Objection. Leading the witness.
Overruled.
Correct, to the point where it crossed my mind he actually may fall out. When he looked back, my heart kind of sank because I felt like it was an intentional act. So that obviously upset me a little bit. He turned forward, he grabbed the steering wheel, he pulled himself up off the seat and cranked the steering wheel to the right.
So let the record reflect that the witness used both hands at the 10 and 2 position to simulate the driver's hands on the steering wheel.
Objection to that.
Overruled.
Based on your memory of where those people were in the road and the SUV's path of travel, what would have happened if the SUV had simply maintained a straight path instead of veering to the right?
Objection. Speculative.
Overruled.
It should have been an open alleyway if he would have went straight.
Did you at any point see the vehicle slow down?
Objection. Speculative.
Overruled.
No, not at all.
Let me know if you recognize what you're looking at after you watch it, okay?
Objection. Hearsay.
Overruled.
Okay, that depicts the red Ford Escape traveling through the closed parade route.
Objection. Hearsay.
Overruled.
Do you know what side of the street this camera is on?
Objection. Speculative.
Overruled.
This camera would be on the south side of Main Street.
Do you see the SUV that you've been talking about in the video right now?
Objection. Leading the witness.
Overruled.
Yes.
You testified earlier that the driver's window was down when it passed you. Does this video accurately depict how the SUV looked, including that window?
Objection. Speculative. No window was open.
Overruled.
Yes.
I move Exhibit 134 into evidence and request permission to publish.
Objection. Hearsay.
That's the red SUV that I saw on the parade that day, and that's the driver that I saw driving the vehicle.
Objection. Speculative.
I would estimate probably 12 to 15 people lying in the road in various positions. It happened upon 2 people. One was an adult male, and then one was a small child, probably 8 to 11.
Did you help anybody else?
Objection. Answered.
Overruled.
Yes, there was many people at that point. We worked together to help at least one other person into the back of a sheriff's squad.
What type of vehicle was that?
Objection. Speculative.
That's not speculative.
The officer who was with me from Franklin, he actually rode with our female victim and went to an area hospital.
Do you recall the first name of that female victim?
I believe it was Marisol.
Marisol?
Objection. Leading the witness. Leading the witness.
Overruled.
Yes.
Any questions for this witness?
Yep.
That's a yes.
Yes. Would you happen to be on duty today, right now, if you weren't testifying? And so right now, would it be fair to say that you are on the clock? Would it be fair to say that you're getting paid right now?
These would be my normal work hours right now.
So you're being paid to testify right now as we speak?
Objection.
Grounds.
Asked and answered.
Grounds.
This is when I'm working, and I've been subpoenaed by the state to be here.
So the state's paying you to testify?
The city of Franklin is paying me.
To testify?
These are my normal work hours.
So would it be fair to say that upon being subpoenaed, you were in touch with the state of Wisconsin?
Specifically, Waukesha County DA's office. One of the people was the gentleman, the DA at the table.
Let the record reflect that the witness made a hand gesture towards the prosecution table and identified Attorney Whichow. Well, let me back up. Was today the first time you ever saw the videos in still frame photo?
No.
Do you recall who you were shown them by?
The
Same
table, yeah.
Same attorney?
Yes.
Let the record also reflect that he's made a right hand gesture to the prosecution table and identified Attorney Whichow again. Do you know of any reason why the exhibits are not depicting what you say you saw?
That video was probably from several hundred feet to the east of where I am.
How would you estimate that distance?
I know where that video was taken from and where I was standing. That's an estimate of about how far.
And you know that for sure?
It's an estimate.
So it would be fair to say you don't know for sure.
Objection. Argumentative.
Grounds.
Sustain.
Grounds for sustaining, Your Honor.
Argumentative.
Just so we're clear for the record and for the jury, your position would be somewhere in here. Would that be fair to say?
Correct. But
Can we put an X down?
Hold on, please. Let him finish.
given the angle of this, it's, if I can draw an X, like as far down here as possible. It's not like any of these people here. So when I put an X here, I am essentially, I'm going to call it way down there. I'm not any of these people pictured. Does that make sense?
No, it actually doesn't. By what you're saying, you would have been approximately in this area. Would that be fair to say?
Object to the annotation. The witness drew twice now where he was, and I think adequately explained it.
Grounds. Where you can see those lights at and the position that you drew yourself to be positioned in, you would estimate that that's 10 feet.
I'll object and move to strike. I think this is a misleading question. We're at the beginning of the video. Those taillights are not the vehicle in question.
Where did the taillights come from then?
A different vehicle.
I believe the question mischaracterized the evidence, so strike the question, strike his response.
Did you move closer to the vehicle or did you move back from the vehicle? What did you do when you noticed that the vehicle was approaching your position?
It happened very quickly. I don't know that I moved in any direction when the vehicle came by.
So to your recollection, you pretty much stayed where you were at?
Yes, it happened very quickly.
Well, let me back up. What will you define as very quickly? Few seconds?
Yes.
You were able to see the driver of the vehicle hanging out of the vehicle, you being concerned that the driver would possibly fall from the vehicle, notice that the driver was looking back and continuing to drive in a straight line. You witnessed all this in a few seconds.
I would not say continue to drive in a straight line. All the rest of that, yes.
You witnessed all that in a few seconds.
Yes.
You made mention to some mechanical problems. How were you able to come to that determination?
That was my initial concern because of the noise that the engine was making.
You thought because of that sound that there had to be some mechanical problems going on with the engine.
I thought that there could be.
But it was your first initial thought, correct? And you were able to hear that sound and come to a conclusion that possibly there were mechanical issues all in a few seconds.
A lot runs through your mind at that point in time, yes.
And you can hear the engine clear over all those people. Would it be fair to say that there were hundreds, even thousands of people present at the parade that day?
Hundreds for sure in my area.
In your general area, hundreds?
Yes.
Would it be fair to say that hundreds of people can get pretty loud?
Yes.
You made mention to sounding like the engine was sputtering. Can you define to the jury what you mean by sputtering?
I heard noises that sounded almost like a popping. In retrospect, it may have been impacts of the vehicle hitting things.
If that is pursuant to the actual engine, how could that have anything to do with something being struck if that's engine, that's inside of the vehicle? Well, let me back up. From your recollection, do you recall there being any tinted windows?
I don't recall.
Can we pull up Exhibit 9? From this picture, there are 2 tinted windows that you can visibly see. Would that be fair to say?
Yes.
You can take that down. Do you know if anyone filed a claim in this incident?
I don't understand the question.
Filed a claim seeking to be an injured party.
Objection.
Grounds.
Sustained.
Have you at any point seen the complaint in this matter?
Objection.
Grounds.
Relevance.
Grounds.
Overruled. He may answer.
No.
Do you know if there's a plaintiff in this case?
Objection.
Grounds.
Relevance.
Grounds. Do you even know if there's a plaintiff in this matter?
Same objection.
Grounds. Being in law enforcement for as long as you have, are you aware that there has to be an injured party to bring a claim?
Objection.
Grounds.
Argumentative.
Sustained. Also misstates the law.
In any of your investigations during your career, were you ever made aware at any time that the state of Wisconsin can be a plaintiff in a matter?
Objection.
Grounds.
Relevance.
Sustained.
You testified that you're getting paid today by the city of Franklin.
Yes.
Okay. State of Wisconsin's not cutting that check.
Objection. Hearsay.
Overruled.
Objection. Speculative.
Overruled.
Correct. It's just the city of Franklin's paying no one else.
Do you get paid more money if there's a guilty verdict?
Objection. Hearsay.
Overruled. It's not hearsay.
No.
When the vehicle was 10 feet away from you, is this where it was on Main Street?
Objection.
Overruled.
Speculative. It's clearly not 10 feet.
The jury will disregard the comment made by Mr. Brooks.
I don't consent to being called that name. Objection to that, for the record.
Could you repeat the question one more time, please?
When the vehicle was 10 feet away from you, is this where the vehicle was?
Objection. Hearsay.
Overruled.
Grounds for the overrule, Your Honor.
He may answer.
The vehicle at this point would still be east of my location.
Is the vehicle now closer to the approximate location where it was near you and your family?
Objection.
Yeah.
Hearsay.
Overruled.
You testified that you saw the SUV veer from left to right. Is that correct?
Objection. Speculative.
Overruled.
That is correct.
Your initial opinion that there may have been a mechanical problem, that changed at some point, didn't it?
Objection. Speculative.
Overruled.
Why did that opinion change?
Objection. Leading.
Overruled.
It changed when I saw the driver and his body language.
What was that body language?
Objection. Leading.
Overruled.
I would describe him as being in an excited state, more excited or almost happy about what was going on, not panicked or scared.
That's all I have. Thank you, Your Honor. What happened as you were walking towards your vehicle?
I saw an SUV driving behind the houses. As I lost visual, I heard a crash. The vehicle then emerged from behind one of the residences. The front end of the SUV was severely damaged, and then it came to a stop. I saw the driver exit the vehicle, looked at it, and yelled, "Fuck." Appeared to be panicked, went back and got items out of the driver's side of the vehicle, and then ran southbound.
Do you remember approximately how many feet it would have been between you and the driver?
Objection. Speculative.
Overruled.
Maybe 50 feet at most.
Could you describe the lighting conditions at that time?
Objection.
Yeah, it was-
Relevancy.
Overruled.
It was pre-dusk.
How would you describe the physical appearance of the driver?
He was wearing a gray hooded sweatshirt and blue jeans.
What about race?
I would
Objection. Speculative.
Overruled.
You've seen photographs of Darrell Brooks in other contexts, is that correct?
Objection. I do not consent to being called that name, nor do I know that individual. And it's
Go ahead. You may answer the question.
speculative.
It's not speculative.
Clearly.
Yes.
The person you saw get out of the driver's seat of that SUV, do you see that person in the courtroom today?
The
Yes.
objection is hearsay. He's speaking as a first eye-hand witness.
Overruled.
And just to be thorough, could we please have Mr. Brooks remove his mask for a moment?
Mr. Brooks, please remove your mask. Thank you. The record should reflect the mask has been removed.
Is your identification in court today colored in any way by seeing pictures of Mr. Brooks in other contexts?
Objection. Speculative.
Overruled.
No.
Can you describe the difference, if any, between Mr. Brooks' appearance today and his appearance on November 21st?
Objection. Hearsay and speculative.
It's neither one of those things. The objection is overruled. The witness may answer.
Objection is irrelevant.
It is relevant.
Not if he identified me already, so he said.
Mr. Brooks, please. The objection's been overruled.
He's got very short hair right now, and he didn't then.
What does his hair look like on November 21st?
Objection.
Overruled.
Relevancy.
Go ahead. You may answer, sir.
He had longer hair.
Do you recognize that video?
Yes. Walking my dog Elvis and walking with my oldest daughter Ava.
Objection. Relevancy.
Overruled.
Do either of those vehicles have, appearing to you today, to have an inoperable headlight?
Yes.
Which one? If you could circle it, please.
Objection. Leading.
It's not leading.
Do you see on the video the person you recall being the driver of that vehicle?
Objection. Hearsay.
Overruled.
What did you do next?
I attempted to call 911 to report a crash.
Did you get through on the first call?
No.
What about the second?
No.
Third?
No.
Did you eventually get through?
Fourth time.
Objection, hearsay.
Overruled.
Pause right now. From the position that you're in and the side street being here, you can see down this street.
No. I didn't see the vehicle driving on Prospect. I saw it driving behind the houses through the yards.
So you were able to see the vehicle behind houses.
Between houses, behind
You said
houses.
behind. You said behind.
Right, through the yards behind the houses.
Why didn't you immediately stop in your tracks and say you just heard something?
I just turned my head to see if I could see anything.
So basically it was just like, oh, do, walking the dog.
Yes.
Why so nonchalant?
When the vehicle emerged from the back of the house, I saw that it was damaged, and then in my mind, I knew what I had heard.
With all respect, that wasn't the question. Being an officer of the law, why would you not investigate that?
I was with my daughter, and I would in no way put her in harm's way.
Well, I would think it would be fair to say that you can handle yourself. You're obviously an officer of the law. You're trained to be able to handle yourself. Would it be fair to say that you could have at least investigated the sound that you heard, the sound like a crash, at least?
Objection. Argumentative.
Grounds
Sustained.
that never piqued your interest to investigate?
That's why I called 911 to report it immediately.
That's fair, but being an officer of the law, you're right there.
Objection. That's not a question. Also asked and answered. Also argumentative.
Sustained.
You don't think you would have an obligation to investigate if someone may have been injured at that point?
That's why I called 911.
When did you make the call?
At some point after you started running,
Who is you?
the defendant, the driver of the vehicle.
Can you zoom in just a little bit? Just a smidge. Can you see anything there?
It looks like something white.
It looks like something white.
Yes, it's light colored.
White color what?
It's light colored.
But you did say white. Would you, from your recollection, say that that was the driver you saw?
I don't know what that is at this point.
You don't-
It's
you
just
don't
a
know?
paused video. If you could play it again.
Well, let's play it again. Whatever you said you didn't know what it was, did you see it move from the position that it was before?
Yes.
You saw the driver in gray. Would that be fair to say?
Yes.
You said long hair. That'd be fair to say?
Yes.
You will be able to see hair if you describe the driver wearing a hoodie?
If it's hanging out of the hoodie, yes.
All fairness, you didn't say it was hanging out of the hoodie. You just referred to the hair.
Objection. That's not a question. And it's argumentative.
At any time, have you read or saw a complaint in this matter?
No.
Seeing as how that you made the initial 911 call, you didn't collaborate with the other officers to try to, piece together what you may have saw?
I'll object to the characterization. That was the first 911 call.
I
Sustained.
didn't say first. I said you made the initial 911 call.
Initial means first, so sustained is to the form of the question.
When you're off duty, do you carry a police radio with you?
Objection. That is irrelevant. It's an officer of the law.
Overruled.
No.
If you did get into a pickle, you wouldn't be able to call for backup, would you?
Objection. That's speculative. Still has a cell phone.
It's not speculative.
Correct.
Your daughter, is she a sworn law enforcement officer?
Objection. Irrelevant.
Overruled.
No.
At the time you heard the crash but didn't investigate it, did you know that the vehicle had been involved in hitting dozens of people on Main Street minutes earlier?
Objection. Asked during cross. Answered.
Overruled.
I had no idea.
And just to clarify again, who was the driver?
The defendant,
Darrell Brooks?
Darrell Brooks.
Objection. I don't consent to being called that name.
Mr. Brooks, I'm sorry.
I don't consent to being called that name.
You see the person who appears to be behind the driver's wheel of the red SUV in that picture?
Objection. What is the relevancy?
Overruled.
Yes.
How would you describe the color of the shirt that person's wearing?
Light gray or white.
Subject matter jurisdiction, Your Honor.
I don't believe the audio's on.
Was I at least heard for the record? Because you just stated that the audio wasn't on.
I heard it.
Did the record hear it?
Yes.
So they heard me say subject matter jurisdiction hasn't been verified or proved yet?
At some point, did you hear something on the radio that concerned you?
Yes, I heard a call for service. It was some sort of domestic disturbance or fight in Frame Park.
Then what happened?
Everyone was starting to get on the radio, and more people started calling for ambulances. I have a collar mic, so my microphone was approximately right about here on my chest. So between trying to listen to the radio microphone and the parade, it was sort of hard to piece together. And I started hearing more screams. It wasn't just screams on my radio, it was screams like in my vicinity.
I just want to make a record. He used his right hand to indicate his, I believe he called it a lapel mic.
Objection. I don't think he said lapel. He referred to the microphone just being here and not using the earpiece. That's just...
Your objection is noted. I did my best to describe the action of the officer.
I recognize it was a red SUV and there was extreme vehicle damage to it on the front.
What happened as the SUV continued southbound?
It accelerated towards me. That is when I knew I had to use deadly force to stop the threat.
Using cardinal directions, can you describe for us which side of you the SUV passed?
Objection. What is cardinal?
Overruled.
To the east of me.
Did you get a good look at the driver?
Yes, I did.
Do you see the driver in the courtroom today?
Yes, I do.
Your Honor, I'd ask Mr. Brooks please remove his mask.
Thank you for doing that, Mr. Brooks. His mask is off.
Can you identify the driver in the courtroom if you see him?
Yes, the driver is seated at the defense wearing a blue tie and blue shirt underneath his suit jacket.
What happened after the vehicle passed you on your right?
I began firing at the driver of the vehicle, and as that happened, he ran over the barricades and ultimately left the parade route.
We've played 7 seconds for you. Do you recognize this video?
Yes, I do. This is the vehicle that was driven by Darrell Brooks during the Christmas parade that drove past me and I shot at.
Objection. I don't consent to it called that name, or nor do I identify it. I'm here in third party. So
Your objection is noted. It's overruled. The witness has previously identified you.
Go
ahead.
Stated for the record.
Do you see yourself at the 10-second mark?
Yes, I do.
Do you recognize this photograph?
Yes, I do. The vehicle that was, again, driven by Darrell Brooks.
Objection. I don't consent to being called that name. Again, for the record, I'm here in third party.
The
For the
objection,
record.
it's on the record.
Objection. Relevancy.
Overruled.
You stated initially that you had heard some radio calls about a possible altercation at Frame Park. Do you recall what the initial report of that was?
My recollection of that was that there was a call for service. It was either a domestic or some sort of physical altercation, and that there was a male armed with a knife and that he was fleeing from the area.
Do you recall if there was ever a knife recovered or a suspect recovered in that supposed incident?
Do you mean like how much later do I know? Like what I know now?
At any time, do you know if there was a suspect, I guess I would say, apprehended or anything that was found with a knife, to your knowledge?
To my knowledge, I do not know if the suspect from that incident, which was you, was located with a knife.
You, what do you mean?
You, Darrell Brooks. I know you were the suspect in that incident, and I know you were taken into custody approximately 30 to 40 minutes later. I do not know if you were armed when you were taken into custody.
I'll let the record reflect that I do not identify by that name, nor do I know any individual by that name. I'm here in third party.
The record's noted, although the jury will disregard the comments, they are not evidence in this case.
How can you know who was involved with it if you didn't respond yourself?
Because you stated at any time this investigation took a long time to complete, and from this investigation we determined that you were the suspect in that investigation.
You determined that?
I did not, no.
Okay. You weren't sure where other officers were stationed, but you gave an approximate estimate. Would that have been officers stationed at different cross streets?
That's correct.
Do you know if those cross streets were barricaded?
I know that there were barricades across numerous intersections. That's how we shut down traffic in the downtown area for parades.
Can you put up Exhibit 1? What do those red lines constitute?
Barricades.
There's a red line there. There's 2 at Buckley.
Well, hold on. You're testifying now. You gotta ask a question. So the jury will disregard that statement.
Are there 2 at Buckley?
Yes.
Is there one at Martin Street? Is there two at Barstow Street? One at Gaspar?
Yes.
One at North Grand and one at West Broadway?
There's two at West Broadway.
And one is on the other side of the star right there. This is what I'm referring to.
Okay, yes, there are
Can
two
you
right
clear
there.
that?
Please clear that, Madam Clerk.
There's two there. There's two at Clinton Street. Can you see those two?
Yes.
There's one at Maple Avenue. Can you see that one? Barricades at all those streets.
Yes.
So would it be fair to say if someone wanted to exit the parade route, they would essentially be blocked in by the officers and barricades?
No.
So it's not fair to say that there's barricades at these streets?
It's fair to say that there's barricades at the streets.
So if someone was leaving the parade route, can they just go right through the barricades?
Based on the previous videos that we just were shown.
Not based on the previous videos. If someone was leaving the parade route, can they just go down these streets that are barricaded? Can they just drive right out of there?
Yes, the video showed that.
How when it's barricaded?
As the video were shown earlier, the vehicle went right through the
Hold on,
barricade.
you asked the question, you have to let him answer that. He's giving you the reason. You asked him how. He's explaining it.
There's plenty of ways to get off the parade route. You can stop after being given lawful orders by officers, and they could have directed you off the parade route in a safe manner. You could have stopped the vehicle at any point, or you could have driven through plastic barricades like you did at Northwest Avenue, where I was located. So yes, you can drive through plastic barricades.
The you refer to as who?
Darrell Brooks, you, the person that's talking.
The you? Clear this right there.
Please? Is that a please?
Can you clear this circle and arrow?
Thank you, Madam Clerk.
Do you recall how long this vehicle traveled along the parade route?
2 minutes maybe?
So what do you mean by after a few minutes you noticed something was going on?
What I meant by that was the initial call for service for that domestic fight. From that time frame to the time that I had shots fired, that is what I mean by a few minutes.
I don't know police protocol, so just asking.
Mr. Brooks, please ask your next question.
I'm getting to it.
Right, but I have to advise the jury to disregard the comment because it's not testimony.
Would it be fair to say that those are barricades that are laying in the street there?
Correct.
Any idea why they were not standing up?
Yes, I do.
What would be the reason?
It was very windy that day, so when they were standing up, they kept on blowing across the street. So we tilted them on their sides so they wouldn't get blown across the road, and they would still stay up there and block traffic.
They would be able to block traffic by laying down.
I guess I don't understand what your question is here.
Would it be much more easier to see them if they were facing upright than laying down?
I think the height difference between them laying down and being upright is probably quite minuscule, because as you see, the legs that are now up in the air are approximately the same height as what the bar would be if they were standing up how they normally are.
And you come to that conclusion how?
Based on my training experience, after deploying barricades on numerous events and working several parades in my work history.
It looks like you're firing your weapon right there. You were ready to fire at that point.
That's correct.
Do you recall what you were aiming for?
Yes, I do.
Can you state for the record and for the jury?
You, Darrell Brooks.
Again, you make reference to the you and the name. How could you determine at this time right now where we're looking at that you knew the suspect's name and the driver? Because you keep referring to you and then you saying the name.
I didn't say at that time I knew your name.
You referred to the name, did you not?
I did not know your name at the time I shot at you.
Who's the you were referring to?
Darrell Brooks.
Again, you say a name. Were you told this?
Yes.
By whom?
I do not know who told me. You were arrested within 30 or 40 minutes, and you were identified as Darrell Brooks, who was the suspect in this incident.
So you either had to hear that name from either a report that you heard or someone told you. How did you come to the conclusion of the name?
I'm assuming someone at the police department told me your name.
And you don't recall who that was?
No.
Even though you can cite the name so clearly and identify it and keep stressing it and stressing it?
That is correct.
So is it fair to say that you're just using the name based off what you're told and not what you were aware of?
What are you asking me?
Is it fair to say that you're identifying this name based off of what you told and not what you knew?
I'm saying the name based on the fact that you were arrested for this incident. You were identified during this incident, and because of that investigation, that is how we know your name.
You do understand that during a police investigation, any suspect is innocent until proven guilty. Would that be fair to say?
That's correct.
And so with that knowledge, why are you so adamant about the name of the suspect that you just testified to not being aware of at the time? That you testified to, in fact, being told?
I'm sorry, I'm confused by your question. Can you say it again?
I think it was clear, but I'll say it again.
Thank you.
Well, I'll say it this way. You also testified to being told of the name. How can you be sure?
I'll object.
Grounds.
Argumentative.
It's been asked, it's been answered, it's argumentative, the objection is sustained.
When asked about what you were aiming at when you fired, you didn't give a definitive answer. You were aiming for the driver?
I felt like I gave a pretty definitive answer. My answer was you, Darrell.
You were aiming for the driver?
Yes. It's pretty definitive. I identified the person I was shooting at.
What part of the driver's body could you see?
When the vehicle was approaching me, I could see the silhouette of his face and upper portion of his body.
Can you describe what you mean by silhouette?
The upper portion of a person's body, I would say, from maybe chest, shoulders, and head and face.
You said silhouette, though. What is a silhouette?
The outer portions of what would be like your shoulder down, your arms to your chest. The silhouette would be the outer portion of it.
That would be the upper half, not the silhouette. What do you mean by silhouette?
Sustained.
Would it be fair to say that that would be equivalent to a profile?
What do you mean by a profile?
A profile would be like a side angle view.
I don't know exactly what you're asking here, but I can tell you when the vehicle was driving towards me, I could see your face, and then as the vehicle drove to my right, yes, then I saw the side of your face. As a vehicle passes you, you see different portions of the driver.
So you aim towards shoulder and up. Silhouette, as you say?
That is what I could see of you in the vehicle when you were approaching me.
The question now, though, is that what you aim for?
I was aiming at you, yes.
At what you can see?
I was aiming at you in the driver's seat, yes.
Would any of those shots be kill shots?
Yes.
Would it be fair to say that firing a kill shot at anyone would terrify him?
I'm sure being shot at is terrifying.
So it'd be fair to say you were shooting to kill?
No.
Judging based on what you see that you testified to, a silhouette from here up, what were you estimating to hit?
Well, my intention was to shoot you in the upper portion of the body. However, my intention was not to kill you. My intention was to stop the threat that you were posing to everyone in the downtown area at the Christmas parade.
Keep referring to the you again. Well, that's not a question. So, do you think it would have been possible to aim at the tire of the vehicle?
No.
Why not? Would shooting the tire of the vehicle not stop the vehicle?
No, it would not have.
A blown tire would not stop a vehicle from moving?
No, it will not.
It'll just keep on. It won't even slow down?
That is correct. I'm trained to stop the threat. You were the threat. The vehicle was the weapon in which you used. So that is why I shot at you.
There's the you again. Pretty clever. Why did you feel the need at the time, not knowing the full extent of what was happening, to use deadly force?
Based on the fact that the radio traffic for people screaming for ambulances, officers were getting on the radio, and it was progressively moving further and further towards me on the parade route, and then officers saying someone was hit, a vehicle versus person hit. Based on that, the vehicle speed, the amount of vehicle damage on a closed roadway during a parade, and people running out of the way so they did not get run over right in front of me. Between all of those things, I knew what had just happened, and that is why I had to take action.
And you knew based on the radio reports?
I would say everything that I had just previously described, all of that encompassing to yes, now I knew what had happened.
Does anyone get struck in those videos that you saw today?
No, not that I saw today.
And you still made the decision to shoot to kill?
That's correct. Actually, correction, I shot to stop the threat. If ultimately you would have been killed from that, that is a possible outcome.
But you did testify that there were kill shots, did you not?
Objection. Argument.
Sustained. It's also been asked and answered in multiple ways.
Do you recall what your shots hit?
Yes, later on when I
No,
gave
at the time. Not later on, at the time where you fired the shots.
Mr. Brooks, you have to
I was
let,
trying to give him clarification on what I
but you
mean.
have to let him answer the question that you asked, and if you feel the need for follow-up, then you can do that.
I was shown a picture of the vehicle and where my round struck the vehicle.
Would it be fair to say that because you describe it as a traumatic event, that there was a lot of things that you probably don't recall about the incident?
I would agree with that. When I started seeing the absolute destruction, I know there's things that I did and saw that I don't really remember and I don't really want to remember.
Will one of those possibly be the suspect that you keep naming?
No.
How were you able to make out the make and the model of the vehicle?
Because that vehicle model has been out for quite some time.
So you've seen many Ford Escapes?
Yes.
The model has been out for some time. What do you mean by that?
It's 2022 now, and that Ford model was approximately a 2008-ish to maybe a 2011, 2010-ish. So yeah, they've been out for over a decade.
The estimate of the years that the model could have been. Would you agree that that's pretty difficult to know just off the bat?
No.
Would that be fair to say?
No.
If someone had a vehicle right here in front of you, you'd be able to tell just by looking at it for a couple of seconds the make, the model, and the year.
Yeah, quite likely. Being a police officer, we run a lot of vehicle registration plates. So when you match the registration to a vehicle on a response, you become very well accustomed to the many different vehicles that are manufactured.
Would it be fair to say that there's a possibility that you could not make out the make and model and year of the vehicle, especially with it being extensively damaged to the front?
No, I was confident that it was a Ford Escape.
Did you notice any tints on that vehicle?
The front windshield that I looked through, I know was not tinted enough to not make me recognize you.
You don't recall, though, for sure, if there were any tints to any windows of the vehicle you saw?
Well, all windows are tinted to some extent. It just depends on to what percentage of tint. Was there any window tint? I'm sure there was, but not to a degree that would prevent me from seeing who was driving it.
Explain what you mean by tint percentage.
So there's different varying degrees of tint that you can put on vehicles.
Can you elaborate for the jury?
I'll object.
Rounds.
You're asking about lighter
About the tint
versus darker.
percentage.
A 50% tint would be a lighter tint than like a 35% tint.
The backer windows are usually maybe a little bit darker than the front.
Correct.
No further questions.
Did those barricades appear to slow down the SUV as it drove through them?
Objection, speculation.
Overruled.
No, it did not slow the vehicle down at all.
Pause. Does that appear to be the same make and model as the SUV you saw driving through your intersection?
Objection.
Overruled.
It's clear.
Yes, it does.
Was the appearance of that person and their clothing consistent with the person you saw driving the SUV through your intersection?
Objection, speculation, two different incidents.
Overruled.
Yes.
The person seated in the driver's seat, does that look like the same person you saw driving that red SUV?
Yes.
Does that appear to be the same vehicle that you saw driving through the intersection of Wisconsin and Maine?
Objection, hearsay.
Overruled.
Yes.
Does that appear to be the same driver of that same vehicle?
Objection, hearsay.
Overruled.
Yes.
Objection, relevancy.
Overruled.
What's going on with that front passenger window?
It looks
Objection, leading.
Overruled.
it looks like it's rolled down.
So if someone had, before this incident, painted that window black, covered it in a black paper bag, and taped it up with duct tape, and then rolled the window down, would that have prevented you from seeing through the front passenger window?
Objection, speculation.
No.
Overruled.
Who was the person depicted in exhibits number 120, number 9, And number 169.
Darrell Brooks.
Thank you.
Objection, I do not consent to being called that name.
Your objection is noted, however, the jury is
You already-
advised to disregard as it's not testimony. It's a comment.
I just wanted to state that I'm here. I'm here on this special appearance on behalf of my client with all rights reserved.
Sir, is this what the vehicle looked like when you first observed it?
Yes, ma'am.
It appears to me that the front bumper is laying on the ground. Is that accurate, sir?
Objection, leading.
Overruled.
Yes, ma'am, that's accurate.
So to your knowledge, no one had touched or disturbed this vehicle, at least since the time you were present, before you photographed it?
Objection, speculation.
Overruled.
To my knowledge, no, there was no manipulation of this vehicle. I did locate documentation of identifying in nature. The name on the paperwork inside the vehicle was one Darrell Edward Brooks, Jr., male black, date of birth 2/21 of 1982.
And in fact, was there more than one piece of paper inside the vehicle containing that same personal identifying information?
Objection, speculative.
Overruled.
Yes, ma'am, there was more than one item.
Was the rear license plate clearly visible?
Objection, leading.
Overruled.
The rear license plate was clearly visible, which listed to a Don L. Woods.
As that was occurring, are you aware of other police activity that was occurring nearby?
I had heard via police radio Officer Luling advised that he was out just a couple blocks away with a male subject identifying himself as Darrell Brooks.
You were flagged down by a Hispanic male running at you waving his hands. Would that be fair to say?
That's correct.
Did you learn any additional information from Mr. Lascano? How do you say it, Lascano?
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 Not while we were traveling to the vehicle.
So you traveled to the vehicle in complete silence?
No, he was trying to direct me with the location of the red Ford Escape.
Did he say he saw anyone driving the vehicle?
Objection, hearsay.
Sustained.
Mr. Lascano already told you was the location of the vehicle, not if he saw anyone driving?
I object. That question calls for hearsay response, Your Honor.
Sustained.
Did he at all tell you that he saw someone in the vehicle?
Objection, hearsay.
Sustained.
Grounds for the sustain.
It's hearsay. To ask him what Mr. Lascano told him would be hearsay.
Do you recall Mr. Lascano yelling that there were subjects standing outside of the building?
Objection, Your Honor.
Hold on. I'm going to excuse the jury while I take up a legal issue. I'll rise for the jury, please. Thank you. Be seated. Mr. Brooks, before I have you question this witness any further, it sounds like to me that you are attempting to offer through this witness the statements made by Mr. Lascano. You may not do that. You will have to call Mr. Lascano as a witness. Your questions are seeking to elicit hearsay.
I'm reading directly from his report.
That would be double hearsay then.
So it's not hearsay for the prosecutor to bring up.
I'm not going to talk about other rulings. I'm directing you not to ask this witness questions that would call for this witness to say what Mr. Lascano said. That is textbook hearsay, Mr. Brooks.
And then I don't think it's fair for me to object to hearsay from the prosecution along the lines of the same type
Yeah,
of thing.
I'm not going to have a debate on what may have come in previously. I know you've made a number of hearsay objections, many of which were not hearsay. I would direct your attention to 908.01 of the Wisconsin statutes. You have that book in front of you that I provided to you a number of days ago at the beginning of this trial or near the beginning of this trial. If you go on to 908.02,
I know what hearsay is.
that's obviously one you may want to look at as well.
don't
And then
need to look at it. I know what it
908.03
is.
has the exception. So unless you can
Clearly.
give me an exception, I'm going to, again, direct
I'm
you
reading
not to ask
directly
these
from
questions.
his report that he wrote.
That doesn't change the fact that it's hearsay.
So
it actually
his report
creates
is
another
hearsay?
level of hearsay. It's an out-of-court statement.
So
not
his-
this witness made, but what another witness made.
I can't read from his report that he wrote.
You can convince me there's an exception to the hearsay rule that applies. Do you have an exception you'd like to offer to the court?
So I might as well not read the report if I can't question him about the report that he wrote.
You're misunderstanding what is hearsay. I'm sustaining the objection. I'm going to bring the jury back out. All right, Madam Clerk, bring the jury out, please.
Clear bias. Clear bias.
Mr. Brooks, I understand
I
you
don't-
may
I don't
disagree
consent to
with
or agree to
the...
being called that name. For the record, again, I'm here as a third-party intervener on behalf of my client. I don't know why that's not understood by now. So I guess I can't bring up the plaintiff either, huh? Tacit agreement.
Thank you, everyone. Please be seated. Continue with your questions, sir.
I gotta tread lightly.
The jury will disregard that last comment.
I don't know why.
And that one as well.
But
It's not your opportunity to testify. You'll be given an
I'm not
opportunity
testifying.
should you choose
I'm
later,
not
sir,
testifying.
but please question the witness.
If I
Thank you.
could ever get to it, I'll do that.
And again, the jury will disregard that statement.
Can you pull Exhibit 99 up again?
Are you asking the state to do that, sir?
Yeah, can it please be pulled up and
Sure.
published?
It can, and it will. All right. It's in the jury box. Continue, please.
From this picture, can you tell what that is?
Based on this picture, you're
Based
right.
on this picture.
Based on this picture, I'm not able to determine what that item is.
Would it be also fair to say we can't even determine if that's outside or inside of the vehicle?
I would disagree and say that is on the exterior of the vehicle,
And how would
between
you
the
make that
hood.
assumption if you can't tell what it is?
Objection. Argumentative.
Grounds.
Sustained.
Are you going off what you found or what you can see from the picture?
I can see from this picture that that item is on the exterior of the vehicle between the hood that is destroyed and the windshield.
And you can tell that from this picture.
Objection as an answer.
Grounds.
Argumentative.
Sustained as to both grounds.
And from this picture, you can tell what this is. How do you come to that determination?
It is in the shape of a headband and it is partially illuminated in this photograph with LED lighting.
It could be fair to say that it's anything. Would you not say that that's fair just from looking at the picture? It's not 100% identifiable from this picture. Would that be fair to say?
Objection. Compound question.
Sustained.
Just from strictly looking at this picture, you can't positively say what the item is.
Objection. That's a mischaracterization of his testimony.
Sustained.
Clear the photo.
You're asking Madam Clerk to please
Clear the
clear it?
photo.
Mr. Brooks, I'd ask that you show some deference to my clerk and not bark orders at her and use simple courtesy. Thank you. And thank you, Madam Clerk.
Will I be awarded the same, Your Honor?
Please ask your next question,
Will I
sir.
be awarded the same, Your Honor?
Please ask your next question.
I will. I just want to know if I'll be awarded the
I have
the
been.
same.
Thank you.
Is it usually procedure to investigate later on after clearing for threats? Would that be the same protocol if you were searching a home?
Objection. Relevance.
Grounds.
Sustained.
Grounds for the sustain.
Relevance.
Between the time that you were flagged down until you actually observed the vehicle, you stated that you don't believe the vehicle was touched in any way in that time?
Objection. That's a misstatement of his testimony.
Grounds, you said something similar to that.
Sustained.
Were you aware of any suspect identification or name? When did you learn of that information, if you learned of that information?
Upon locating the identifying documents inside the vehicle,
Did you immediately regard that information to be the possible suspect?
yes, since it was in the vehicle that was heavily damaged, the red Ford Escape with the bullet hole in the windshield, yes, I believe that that information indeed belonged to a suspect.
Did that information match the identity of who the vehicle was registered to?
No, the identifying information, again, for Mr. Brooks that was inside the vehicle did not match the registration of the vehicle, which was Don L. Woods.
For the record, I don't identify by that name. Yet again, stating that for the record.
The jury will disregard that commentary by the defendant, and it also mischaracterizes the witness's testimony.
It does not. I was just stating for the record.
Again, the jury will disregard that
So,
commentary.
There's a possibility that at any time, multiple people can utilize that vehicle. Would that be fair to say?
Objection. Speculation.
Grounds.
Calls for speculation. Sustained.
Would you agree that a vehicle registered to one person and information found by another person constitutes that more than one person used the vehicle?
Objection.
Grounds.
Go ahead. Your
Grounds.
The question was, does that prove that more than one person could drive the car? That's an improper question.
That wasn't the question.
sustained assumes facts, not in evidence.
State that last part again.
It assumes facts, not in evidence. Your question.
Is it fair to say that people leave all types of information in family members' vehicles at any time?
Objection.
Grounds.
Irrelevant. Speculation.
Sustained.
Grounds for the sustain.
Ask your next question, Mr. Brooks, please.
May I have the grounds, please?
The objection has been sustained.
May I have the grounds? Is that a tacit agreement?
Sir, I don't know what a tacit agreement is, so please keep going.
Clearly know what it is. Would it be fair to say at some point you've left items in other people's vehicles?
Objection.
Grounds.
Relevance.
Sustained.
Grounds for the sustain.
I've sustained this question multiple times, multiple
wasn't
ways
the
you've
same
asked it.
question.
Next question, please.
May I have the grounds?
90611.
May I have the grounds? Is it to relevancy? Is it to hearsay?
Under 90611, ask your next question or I will cut off your cross-examination.
I have to give the grounds though, Your Honor, especially if I'm merely just asking for the grounds of the sustain.
Sir, ask your next question.
What's the point of me asking questions if I can't ask anything?
The jury will disregard his commentary that he just stated right now.
Did any of the people that you spoke with give any reason why the suspects that they identified would run from the scene?
Objection. Speculation
Grounds.
also calls for hearsay.
Grounds.
Sustained.
Grounds.
Next question, sir.
After leaving from the scene, were you instructed to make contact with anyone at that point?
Yes, I was.
May you state for the jury and for the record?
District Attorney Sue Opper.
Are you referring to District Attorney Sue Upper?
Yes, that's what I said.
Can you point her out for the jury?
She's seated at the prosecution table wearing the gray cardigan.
Let the record reflect that the witness has identified Attorney Upper. After your part of the investigation ended, were you able to obtain any more information that you didn't know?
Objection. Vague. Calls for speculation.
Sustained.
Grounds for the sustain, Your Honor.
Please ask your next question.
Would you by chance know who the plaintiff is in this matter? Grounds.
Relevance.
Grounds. Ever seen or talked to the plaintiff? Had any physical interaction with the plaintiff in this matter?
Objection. Vague and compound
Grounds.
question.
Do you even know if there's a plaintiff in this matter?
Objection.
Grounds.
Irrelevant.
Would it be fair to say that whoever files the complaint is a party to the matter?
Objection.
Grounds.
Beyond the scope of the witness's
Grounds.
knowledge, Your Honor.
Sustained. Next question.
Grounds for the sustain, Your Honor.
Next question, please.
Any reason why the state of Wisconsin would be identified as the plaintiff when they did not file the complaint?
Objection. Argumentative. Misstatement of the law.
Grounds.
Sustained.
Grounds for the sustain, Your Honor.
Ask your next question, please.
Was that the grounds?
Next question, please.
The jury deserves to know these.
The jury will disregard that last statement.
They need to know.
I've sustained the objection, sir.
I'm aware that it was a sustain. I'm aware. I just wanted to know the grounds. You can't keep hiding stuff from the jury.
Mr. Brooks, the court is not hiding anything from anyone, and the jury will disregard that last statement. It is not evidence in any way.
Would it be fair to say that any case has a plaintiff?
Objection.
Grounds.
Lack of foundation beyond the scope of the witness's knowledge.
Sustained.
Can I rephrase the question?
I can't say whether it will be answered or not.
I can't rephrase, just so we're clear.
I don't know what the question will be, sir.
Are you aware that in any case brought into a courtroom, there has to be a plaintiff?
Objection.
Grounds.
Same question.
Grounds is
It
not
also
the same
misstates
question.
the law, so sustained.
If there's no plaintiff, how's there a case?
Move to strike.
The jury will disregard the last comment made by Mr. Brooks.
Grounds. If there's a defendant, there has to be a plaintiff.
Mr. Brooks, please stop. The jury will also disregard that statement. It's a misstatement of the law.
Based on what law or fact, Your Honor?
One final time, you may ask another question, and it must not be along the same lines, or I will ask the state whether there's any redirect.
Do you know of anyone who filed a claim in this matter?
Objection.
Grounds.
Irrelevant.
Grounds.
It's also vague, so I'll sustain it.
So the grounds is vagueness?
And relevance.
Is it vague or is it relevance?
Sustained, Mr. Brooks. Next question.
And have you seen any news reports?
Objection. Relevance.
Can I finish the question?
I'm going to sustain the objection without hearing the rest of the question. I don't see how it would have any relevance. I'll let you make an offer of proof after or outside the presence of the jury, and if necessary, you can recall this witness. Next question.
In that case, then, since that is stated on the record, no further questions. I would like to finish at some point.
Sir, finish your cross-exam as to
Just
that
said
limited...
no further questions.
Okay, but as to that limited topic only. So if there are other things outside that topic, please finish your questioning.
I just said 2 times. I'm going to say it again. No further questions.
All right, thank you then, sir. I'm going to excuse the jury to take up a legal issue with the parties, and hopefully we'll have you brought back out shortly. You may make an offer of proof as it relates to what information you believe this officer would provide about news reports that he has seen.
So the offer of proof would just be to that one question?
What would the question be?
The question would have been, if I was allowed to finish it, Had he seen any news reports directly connected to the incident? Same thing that many other witnesses have been asked. It was never sustained in.
What relevance would this particular witness seeing news reports have to his testimony?
The same thing that any other witness that was asked the same question.
Which would be what? You have to be specific, sir. I'm not going to assume I understand what you are saying.
Have they saw any reports related to the incident? It's relevant to anyone who gets on the stand's testimony.
What's the legal basis you believe it's relevant to his testimony?
It obviously forms an opinion.
Explain to me any legal basis that I should allow that question to be asked.
I don't understand how you want me to answer that. I've stated the reason why I asked the question.
No, you stated it's obvious, but it's not obvious to me, so I'm asking you to explain it.
I just clearly stated, that it goes towards biasness. That would be relevant.
Wait, it goes to what?
Biased.
Bias?
Biased.
No, bias. B-I-A-S. There's no T at the end. Bias. I want to make sure I understand your reasoning correctly, sir. So you're saying it goes to bias. How does it go to bias of this witness?
How would it not go to if you see something in the news?
It's not a proper legal argument, sir.
Okay, well, I don't know how you want me to answer that.
How would what he saw subsequent to his investigation impact either what he did beforehand or his testimony here? You have to make an offer of proof as to that. Without that, I'm not going to allow it.
You didn't allow it anyway, so what do it matter at this point?
I'm giving you the opportunity. It's called an offer of proof.
Okay,
I said I would recall the witness if I determined.
I'm well aware what an offer of proof is.
Okay,
I'm well aware.
So make your offer of proof.
I don't need to. It's clear. It's very clear. I don't see anything funny either.
It's not funny, sir. It's a circular argument.
I wasn't referring that to you. The person that it was referred to know who they are.
Well, let's stay on task, please.
I'm trying to.
You're claiming it goes to bias, but in what way?
May I say this for the record, Your Honor? It's hard to stay on task when it seems like the prosecution can ask essentially anything they want to ask.
Mr. Brooks,
but then when I
had an objection before. Well, here's the thing. You want to go off target and you want to bring up things from the past. When an objection has been made, it is my obligation to rule on it.
I'm aware of that, Your Honor, but I'm also aware of the fact it's clear that I object quite often, and every single time I object it's just thrown to the side every single time.
Well, I would disagree with that characterization, sir. And I make my rulings in this case.
Why would you disagree with that?
I'm like an umpire.
Point out one time?
I'm like an umpire in a baseball game, sir. I call and see the legal objections as I see them.
Are you kidding me?
That's exactly what I do. I'm an umpire, sir. I am a referee in this trial.
If you're the umpire,
and let me finish.
Okay.
Let me finish, Mr. Brooks.
I apologize. I'm letting you finish.
You make a number of objections. I rule on them, and you disagree with them. But that doesn't mean I'm casting things aside. I'm making a call based on the rules of evidence, which once again, I'll point out, I gave you, sir, near the beginning of this trial, so that you would have a better understanding of what those rules are. If you choose not to read them, that's fine. But you cannot then claim there is somehow foul play because you haven't read them and you don't understand what they are. Your ignorance of the law is not a defense for any of this. Okay, and you getting frustrated with me because you don't understand that, I mean, it's just what it is. But I'm calling these legal shots as I see them. You want to ask this witness who had limited involvement regarding a part of an investigation related to that vehicle. I don't see the relevance, even to bias. You haven't given me a legal or factual reason to bring the witness back on the stand and to question him about his viewing of any news reports. So with that, we are going to take a very short break. The jury's been out for a little bit, and when we come back on, the state should be prepared to call the next witness.
Can I release rebuttal to what you just said since you asked me not to?
I don't need a rebuttal, sir. You may not agree with me, but I've made
It's not about agreeing. You just told me not to interrupt you, and I didn't. So I at least deserve the chance to put on the record a rebuttal.
What would you like to put on the record as it relates to the specific issue, not subject matter jurisdiction, not
now you
whether
said
the state's doing other things? I'm only asking you to address the offer of proof.
No,
if you have something, go ahead. But only as it relates to that.
I want to address your position because you said you're like the umpire. right?
Well, I'm not getting... Okay, go ahead, sir. I'm not sure why you need to respond to that.
Because it needs to be on the record. If you're the umpire, that means you're the referee. You're not reffing fair if the jury's not allowed to hear things that's important for them to know.
Again, just because you believe the law means you have a right to question all these witnesses about who the plaintiff is and about subject matter jurisdiction doesn't
I didn't question
make it
anybody
so.
about that. That didn't have nothing to do with a witness. I've
You
never
want to
once
question
questioned a
these
witness
witnesses,
about subject
sir,
matter
about
jurisdiction.
whether they are aware of complaints. And the funny thing is, sir, I sometimes let that question be answered for reasons that are completely different, I believe, than why you want them in. I am not going to explain that because I don't have to
say
explain that.
what's my reason for asking it.
Well, I believe you've made it very clear, sir. So here's the bottom line.
I don't.
One of my roles is to be the umpire.
Then you got to be fair, Your Honor. You're a public servant.
I am fair, and I'm going to follow the rules of evidence.
Your Honor, this is why I say that.
Unfettered questioning.
This is
of
why I say
witnesses.
that. You're not being fair.
I respect
You're not
that
being
you
fair,
might
though.
not think it's always fair, but
It's
I
not.
disagree. I think it has more to do with your lack of understanding of the rules of evidence and the rules of procedure, which you knowingly, freely, and voluntarily and deliberately made a choice to represent yourself.
You keep
I
saying
warned
that
you at
because
that
it sounds
time,
good
sir.
on the
You did
record,
that
but
at
it's
your
not.
peril.
It's not accurate. When you gave me the paperwork, Your Honor, I gave it back to you.
I'm not going in. I didn't say that, sir, so we can go back and rehash all of those things.
But you know you accepted
All right.
the way that I gave you the paperwork back. So once
and
you
I made
accept
findings
that,
on the record, which I will stand by.
you got to
For
call
off
it
the
fair.
record, sir.
You got.
I want to bring to the party's attention that the court just now issued a decision and order. I've signed it, and I will provide the parties with a written copy here in court. It addresses the matter of subject matter jurisdiction.
So we're going to address it.
I've issued an order. I'm going to give it to you. There's a written decision now denying your motion to dismiss.
Is that including verified proof that you have subject matter jurisdiction? Because it has yet to be verified or proven.
Mr. Brooks, you keep making that statement, but it's a misstatement of the requirements in the law.
So it doesn't have to be proven?
You are going to get a written decision, as I had an opportunity to finalize that over the break.
I accept for value and return for value this document.
Thank you for noting that. All right, bring the jury out.
Is that verified proof that you have subject matter jurisdiction?
The decision and order speaks for itself, sir.
Is it verified proof that you have it?
Sir, I believe it answers your questions.
I don't believe
unequivocally.
so. There's no verified proof if we're in common law or admiralty law. What court is this?
I believe your answers will be in that decision and order.
I don't believe so.
Well, have you read it yet?
I don't have to.
Okay.
I accept it for value and return for value, so.
They're in there, sir. It's a final order for
Verified proof is in there? Verified proof is in
So if
there?
you'd like to challenge that, you can take that up with the appellate courts.
Verified proof is in there?
All right.
Because I don't think it is. Proof of claim is not in there either. No one has a claim.
Do you recall at some point hearing a noise or something that was out of place outside of your window?
Yeah, when I was sitting down, I heard like a big screech, and as soon as I look out, there was a vehicle that I had never recognized. I was able to see somebody just jump over the hood of the car, dash away, and when I saw the car, saw that it was really beat up. Wasn't really sure what was going on. Sorry.
I'll cut you off there. Could you see whether there was any damage to the vehicle?
Yeah.
Answered that already.
Overruled.
Said it was
May
beat up.
answer.
Was this person directly below you, or was it off to the side?
It was more.
Relevancy.
Overruled.
So would that have been toward or away from Maple?
Objection,
that would have
being
been-
a witness.
Overruled.
It was towards Maple Avenue.
When you are standing in your driveway, if you wanted to go to downtown Waukesha, would you go left or right?
Left.
Objection. That was asked and answered, and he already answered that question.
This question has not been asked or answered.
It was left.
Objection. What's the relevancy of all these photos?
Overruled.
That's sort of the back part of our house. Those are sort of some of the logs. One of them was actually dragged into our driveway.
You recognize what we're
Objection.
looking at here in exhibit? I'm sorry, there's an objection.
Where's the relevancy of this?
Overruled.
What is this?
The red SUV in my driveway, all beat up.
And you referenced a stump earlier. Can you point that out for us? Maybe circle it for us?
Objection. Relevancy as to a stump. What does that have to do with?
Overruled.
Stump of log would be sort of on that part of the picture.
Was that stump in that position in your driveway before you saw this red SUV?
No.
Objection. Relevancy.
Overruled. It's relevant.
Do you know if any of those three vehicles sustained damage on November 21st?
Objection. Hearsay.
Overruled.
Objection. Speculation.
Overruled.
Do you see an orange cone in this photograph?
Objection. Relevancy.
Overruled.
What, if anything, do you see in the immediate vicinity of that orange cone?
Objection. Relevancy.
Overruled.
Do you recognize an object within a few inches of that cone?
Objection.
Yeah.
Speculation.
Overruled.
I don't personally recognize it.
When you say you don't personally recognize it, what do you mean?
Leading. Objection. Leading.
Overruled.
Our family doesn't own it.
Is this what these stumps looked like earlier in the day on November 21st, before you saw the red SUV?
Objection. Relevancy.
Overruled.
They did not.
To your recollection, was that car parked in your neighbor's backyard before you saw the red SUV?
Objection. Speculation.
Overruled.
No.
Can we now, so just for the witness, exhibit 143, where in the vehicle do you see damage? The front, the back, both, or neither?
Leading. Objection.
Overruled.
Towards the driver's side, back left.
If you were to drive a vehicle between that porch and that Infinity vehicle, you would be driving toward or away from your house?
Objection. Hearsay.
Overruled.
Objection. Speculation.
Overruled.
You'd be heading towards the backside of our driveway.
The hood was pretty jacked up. Would that be fair to say?
Yeah, if we're talking about the red SUV,
The vehicle in your driveway.
there's multiple vehicles in my driveway.
The one that's specifically in your driveway in 68?
Can you see on your screen, Mr. Burke?
Yeah. And for the record, I do not identify by that name or consent to being called it, for the record. You said you observed the driver of that vehicle jump over the hood.
I wouldn't say necessarily jump over the hood, sort of evading it.
Would it be fair to say that you were subpoenaed to come and testify today?
I was subpoenaed to come testify.
Do you recall by whom?
Not the state, but the city of Waukesha, or the town of Waukesha.
District Attorney's Office, an officer, or?
When I received the subpoena letter, it was just from Waukesha.
As we saw in the photos, there was a neighbor whose car had scrapes. Do you recall if they filed any claim in regards to the scrapes?
They probably figured that the damage that was caused was from the vehicle that was in the parade, so I don't think filing a claim was probably their main concern.
Did you have any contact with any law enforcement about the incident of that night?
I was contacted later on by victim help, but we never really reached out.
You just said victim help. Can you explain what victim help is?
For people that suffered from the parade, and we were also reached out because our house was in the whole mess, and
Right, with
we sort of
vehicle being found in your driveway.
we were all pretty shaken up. I was pretty shaken up, sort of scared, sort of frustrated too.
If you had, a few concerns after the incident, what prompted you not to follow up with victim care?
Objection.
Grounds.
On relevance grounds, I'll sustain the objection.
And are you aware who the plaintiff is in this matter?
I guess you can say the defendant, Darrell Brooks.
The defendant would be the plaintiff?
Or not the defendant. Could you kind of sort of
The plaintiff would be who is actually bringing the claim.
Oh, the plaintiff bringing the claim?
Who's bringing the claim?
I'm confused by the questioning, if I'm going to be completely honest.
And I'll object and move to strike the line of questioning for relevance.
Grounds
Well-
answered.
He answered at my stand. Next question, please.
Does a mobile phone or computer, either in person or by any electronic means, do not read any newspaper reports, any other electronic application or tool about this trial. Any information you obtain outside the courtroom could be misleading. Do not communicate with anyone about this trial or your experience as a juror. All right, I'll see everyone on Monday morning at 8:30. We are in recess. Thank you, everyone.